you. Ms. Pinnock?
Please support, Your Honor.
Yes.
Good morning. Nathaniel Rowland did not have a mark on him. Not a cut, not a bruise. They checked him, and nothing. The unidentified people that the state wants to just brush off like they're no big deal, they do matter. DNA evidence does matter. If it didn't, we wouldn't spend an entire afternoon of this trial talking about it. So you cannot brush it off. You cannot stamp your feet and hit podiums and say it doesn't matter. Because the unidentified male A, the unidentified male B, and every multi-person mixture that has 3 to 5 extra people in it, they do matter. And we can't forget that in a lot of those mixtures, Nathaniel Rowland is excluded. He's not there. So it's somebody else. Now the problems with this case, the way I see it, is that back in March of 2019, everybody started jumping to conclusions and just making up their minds on something, when we know on March 30th of 2019, law enforcement literally knew nothing. What they knew was that Samantha Josephson had gone missing. What they knew was that her body had been located in Clarendon County. And what they knew at that point is that Nathaniel Rowland had been pulled over by Officer Kraft, and there was liquid in the car that they at that point suspected was blood. The initial report came back from the lab confirming that it was in fact blood. Nobody has stood up here and said that Samantha Josephson's blood was not in that car. Nobody has stood up here and said that Nathaniel Rowland was not the one driving the car. But her blood being in the car and Nathaniel Rowland driving the car does not mean that he is the one that killed her. And that is what this trial is about. He's not charged with driving a car. He's not charged with trying to sell a cell phone. He's not charged with not calling the police when he should have. He's charged with murder. He is charged with kidnapping. And he is charged with possessing the weapon during those 2 crimes. That's why we're here. Not for what he might have done starting in the late morning hours of Friday, but what happened between approximately 2:07 on Friday morning to when Miss Josephson was located in the woods. That's what this trial is about. At the beginning, a little over a week ago, it was 8 days ago, Mr. Gibson stood before you and he told you that the simple answer is the easy answer, or the simple answer is the right answer, or something along those lines. There is nothing simple or easy about what's happened in this courtroom this week. Nothing. In fact, the opposite is true. We all know this. The simple answer, typically not the right answer. It's the giveaway. It's the one you can fall back on. Go ahead, snap it, it's done. And starting 2 years ago and continuing to today, that's the narrative that has been adopted by law enforcement. It's the narrative that was adopted by the solicitor's office, and it's the narrative that they've given you throughout this trial. Now, I'm not going to go back through every piece of evidence, every witness that you've heard of, that you heard from. You know, y'all were listening, y'all were paying attention. We were watching. You know, y'all watch us, we watch you. We know you were paying attention. So I don't need to go back through everything. But there are, a few key pieces that I think show and prove that the easiest answer is not the right answer for this case. Now I want to start where I believe the narrative is kind of getting skewed a little bit. And luckily, this video is in evidence. We're going to start with Officer Kraft. The initial officer that, hit his blue lights, pulled Nathaniel over, and conducted the traffic stop. What you were told was happening in that video is that Nathaniel Rowland was driving through 5 Points, 1 block away from the bird dog, when a traffic stop was initiated. What happened was Nathaniel Rowland was traveling out of the Shandon neighborhood, had come up to the stoplight, gotten to the turning lane to turn left, and turned left. He did not go into 5 Points towards the bird dog. He turned left. Officer Kraft then hits his blue lights. And you see Nathaniel Rowland driving his car, put on his blinker, get into the turning lane. It's all on video, you can see it. It's a turning lane to turn left to stop for the traffic stop. And then I believe the testimony was when the car stopped, he started talking, everything was fine. Then we get him out of the car, and just like that, he's gone. That's not what happened. And you don't have to take my word for it because you'll have the video. It's not just believe what I'm telling you because I'm telling you. It's watch it for yourself and see when the narrative leaves what the evidence shows. Because what the evidence shows is that Officer Kraft asked him out of the vehicle. He got out of the vehicle. He was standing there. He literally gets out of the car and puts his hand in his pocket and is standing there. Kraft grabs his arm, yells at him, "What, are you crazy?" The other officer who was on scene jumps at him. You can see on the body camera, Nathaniel looks around because the other officer lunged in his direction. And at that point, Nathaniel ran. Am I saying that he should have run? No, I'm not justifying why he ran, but that's what happened. He made the choice to run when one officer grabbed him, yelled at him, and another one jumped at him. He took off. He shouldn't have, but he did. So he did not tuck tail and run as was just presented to you when they start telling him why they stopped his car. That's not what happened. Don't let the narrative cloud what you can see with your own eyes. You've also heard nothing from anybody about the amount of blood in this car not being a significant amount of blood. I haven't said it, Ms. Good hasn't said it, Mr. Pillinger hasn't said it. There was a large amount of blood in this car. That was not an issue in this case. Nobody was pretending like it didn't exist. It's there. But what we know from the testimony that you heard is that blood transfers, and it transfers easily. You don't even need a DNA expert to tell you that. Anyone who has ever helped a child with a cut, helped a friend with something, if somebody is bleeding, you're going to get that blood on you. And with the amount of blood in that car, it is not a stretch of the imagination to think that everything else in that car has blood on it. Literally everything. Steering wheel, gear shift, air vents, seat belts, clothing. It got on people, it got on a baby's shoes. Everything in that car had blood on it. And that's a fact. You don't have to touch something in order to get blood on you. You have to come in contact in some way with the blood. And the items that were in the car prior to the blood being in the car have blood on them. That's not a leap and a bound. That makes perfect sense. So prior to them, y'all remember, prior to them coming out and processing the car, the SLED agents, the crime scene investigators, were out in the woods. They got the call out there first because Ms. Josephson's body had been located. And you heard the testimony. We wanted to be as specific as possible when we were talking to these investigators about why they did certain things, what they did, the reasons behind them. Tell us how you did your job. Because these crime scene folks, they did their job. They collected hundreds of things. They don't know what they're looking for when they go out. They are given a basic, here's what we think is happening. They establish the crime scene, and then they start documenting. They document with notes, they document with pictures, because they need to try to make sure that they gather all possible information that could be beneficial in this case. And that's what they did. They collected beer cans, cigarettes. We know what they did. They took pictures of dirt. We have pictures of dirt roads. We have pictures of trees. We have pictures of footpaths. Because that's what a crime scene investigator does. They document and they collect. We also have pictures of Ms. Josephson's body when it was in the woods. Because crime scene wants to make sure that they can, at a later date, explain clearly how a body was found, what they observed around the body, and preserve any possible evidence that might be present at that time. Because they know that certain types of evidence is very fragile. So if you can get it, you need to get it before the possibility of contamination. And so that's what they did. A week ago, Ms. Good stood in front of you, and she told you Samantha Josephson had DNA under her fingernails. Y'all heard the testimony. It's under her fingernails. And the crime scene report has that her fingernails were ripped. Ripped. But when investigator Jazik was testifying, and the state's going through and putting in picture after picture after picture, they didn't give y'all any pictures of her hands. Because to them, that's not important. There is not one photograph of Ms. Josephson's hands, of her fingernails, prior to that autopsy that would show you the true length of those nails when they found her body in the woods. Not one. They did not give it to you to look at because they don't want you to think about it. Pictures were presented to y'all, and they're here. You can take all of these back and you can look at them. The scene itself in the woods, I think, is also important for a number of other reasons. Dirt roads, brush, a wooded area. You couldn't see Ms. Josephson's body from the road. You had to come into the footpath some to even see where she was. And just imagine, it's pitch black. Somebody drives a car into the middle of nowhere, drags a body out Not a street light in sight. It is pitch black through a wooded area with not, it's not the blanket, you can't see anything woods. It's those really annoying pointy sticks that scratch you when you go through them. Those kind of trees. Not a scratch. Nobody fell. There's not debris on any of the clothing that they found in the car that they're saying that Nathaniel Rowland was wearing. Nothing from the woods is on Nathaniel Rowland's clothes. Nothing's on his shoes. And not just dirt and debris. If somebody's going to be committing a murder, folks, you're not doing it in slides. You're not doing it in flip-flops. There are at least 3 pair of shoes in that car with no blood on it. A significant bloodletting event, and there's not a shoe that is covered with blood. The slides that they got, there's a mixture of DNA, another mixture of DNA, and I'll come back to all of the DNA stuff in just a minute. But no, people aren't going to commit murders wearing flip-flops. It doesn't make any sense. It makes absolutely no sense. That person would have been covered. Covered. The next scene that was processed was Maria Howard's house. And they kind of went back and forth. I probably have the timing off a little bit, but between Maria Howard's house and the car, there was a lot of processing. A lot of items were collected from her home as well. And Maria is one of those witnesses. She's kind of tough, because you have to acknowledge that she's kind of in a situation. She goes and meets with law enforcement 3 days after Nathaniel's in jail. She tells them that she's been working double shifts and, she's been tired and all of these things. But when she testified, it's little things. You have to remember what you tell people if you're going to keep that story going. We've all heard that. If you're going to tell a lie, you better remember what it is. So if you're working double shifts, that's the reason your daughter's not with you, which is fine. Everybody needs help. But you're with Nathaniel every day. He doesn't spend the night at my house, but I know what he looks like when he wakes up. Okay? When he showed up, he didn't have my shirt, and then he disappeared and came back with my work shirt, and it was wet because he had washed it, and so I put a wet shirt on and went to work. Okay, none of that makes sense. I don't know what she's talking about. I wish I could offer you an explanation as to what she's talking about, but none of that stuff makes any sense. Why she would get into a car covered with blood and just go on about her day like everything is fine. That doesn't make sense. Why she didn't call the police if she was so scared. You heard her, she told, I was too scared. I couldn't call the police, I was too scared. Well, when she got to work that day and she texted her mother, she said, "Baby tried, LOL. My shirt is wet as F. He will not be wasting, I believe she said, washing clothes ever. Have a good day. Love you." That's not somebody who's terrified and scared and trying to figure out what's going on. That's somebody laughing with their mother that her work shirt is damp and she's not going to let Nathaniel Rowland wash her clothes anymore. Not somebody who's scared of him. A number of things were taken from Maria Howard's house, and that's why I say I feel like she finds herself in a position. It's her house. She shares that house with her child. And all of these bloody items are found at her house. And she can tell us all she wants to that, I didn't touch anything, I don't know what was going on, I didn't do anything. Her DNA or her fingerprints are all over those bags. All over those bags. She can say whatever she wants. I don't know what's going on in her head, but her fingerprints and her DNA all over those bags. And one of the more interesting things that Maria provided to law enforcement and told y'all the other day is when she realized that her kid was still at daycare. Now the way she describes it, she realizes she needs to get there. Her mother's asleep because she's a school teacher and she was in bed, totally fine. So what does she do? She tells Nate, I need to borrow, we need to go get my daughter. My mom didn't go pick her up. Okay. So Maria's driving. And she told y'all that while she's driving, Nate put on gloves and continued to clean the inside of the car as they were driving down the highway. That he sat there in the front seat cleaning off this multi-tool that she had seen him with, whenever before, wearing gloves, cleaning it off. This is what the tool looks like now. It's been through processing, it's been cleaned, right? The state showed you what this tool looked like when they found it in the trash can. It's not clean. It's got blood, hair, and DNA all over it. He was not sitting in the front seat of a car, riding down the highway to Northeast Columbia, cleaning a murder weapon in the front seat of the car. That did not happen. She came in here and she told y'all something that did not happen. That's the tool that they found in the trash. That's what it looked like. It was not clean like that. Wearing gloves and DNA. I'm almost confused after all these years why it is that we even bother with DNA testing. And I only started thinking that after sitting in court today. Why do we take swabs and submit them to analysts if we're going to stand here and try to convince y'all that it doesn't matter what they say? Then why do we do it? I don't have an answer for that. If we're not supposed to pay attention to what the scientists tell us, then why are we sending stuff to scientists? It doesn't make any sense to me. Because that's a theme that has continued to come up throughout this case, and it all boils down, with the bloods, it all boils down to what was found on this and where it was found. We know that Nathaniel's DNA, there is a weak support for the inclusion of his DNA in a mixture found in this general area of the tool, right? But what did not come out when the prosecutors were questioning Agent Dwayne is that there was a mixture. I asked her that on cross because it was skipped over. There is a mixture of DNA on that tool. There's a mixture of male DNA on that tool. And the major contributor, y'all remember, Agent Dwayne told you, major means the most DNA present. The major male profile on that tool is not Nathaniel Rowland. It is a weak, and that's not just a word that I'm using, that is their standards for interpretation, a weak support for him to be included on that tool. And that also it kind of brings it back around. If the state is going to stand here and tell you over and over and over again that Ms. Josephson didn't have Nathaniel Rowland's DNA under her fingernails because he was wearing long sleeves and gloves, then how does DNA get on that? You cannot straight face stand here and say, she doesn't have his DNA on her because he was covered up, but his DNA is on that because he wasn't covered up. You cannot talk out of both sides of your mouth. You cannot argue he was wearing gloves at one point, not wearing gloves at another, to explain why his DNA is present somewhere and excluded from somewhere else. There's lots of testimony. Like I said, I'm not going to go back through all this because honestly I don't understand a lot of it. The cell phone stuff with the towers and the data, all of that's technical. I can talk to experts, I can listen to the experts, but that is very technical stuff. What we know about the cell phones is that there were 2 phones that were associated with Nathaniel Rowland. We know that one phone, Agent Grabsky, was, he provided y'all with a map. And that map hit off of towers in Columbia, Sumter, Clarendon County. But we know there's a second phone. And in the records that y'all have, all of these phone records right here, the state provided you the proof that Nathaniel Rowland does not have both phones associated with him all the time. And that's important. Because the phone expert testified that the phone doesn't, wherever the phone is, it doesn't mean the person is. So we know that one phone associated with Nathaniel Rowland was bouncing off of cell towers. And we also know that Nathaniel Rowland does not have both of his phones on him at all times, because you don't call yourself and talk to yourself for almost 2 minutes. You don't text message yourself and respond from your 2 separate phones. The records that they gave y'all have the phone calls and have the text messages between the 2 phones that they are saying are associated with him. People don't have conversations with themselves, not over cell phones. So we know that somebody else has Nathaniel's phone. Just because a phone hits off of a tower, that does not mean that the person is there with it. Now, Mr. Goldberg talked about the ATM video, and Mr. Martin's video, the gentleman who works in the solicitor's office. I'll start with the ATM video because it always comes back to the close. I believe that's what he said. Always comes back to the close. Well, the clothes were located, I don't know in which bag, but the clothes were located, there's a black jacket. There's been lots and lots and lots of talk about a black jacket. The black jacket is important because if you're when dealing with a case where somebody is stabbed multiple times, you have to understand that that means the assailant is right up on that person. If somebody gets shot, you can get shot from across the room. You cannot stab somebody from a distance. It's up close and it is personal. So in that scenario, the person wearing the black jacket, they believe is the assailant. They tested that jacket. They tested it for DNA. They found DNA. They tested multiple places on the jacket. They tested the cuff. You put a jacket on, it's going to be around your cuff. Nathaniel Rowland's DNA is not on that cuff. They tested where they said there were striations, where the scratch marks were, that was potentially nail damage from the fight that Ms. Josephson put up. They tested it. Nathaniel Rowland's DNA is not there. And the excuse that's provided is, well, just because it's not there doesn't mean he never wore it. Then I ask you again, folks, what is the point of having these folks come in here to tell you what they did, what the results are, so we can just turn around and brush it off like it doesn't matter? They also tested the neckline of that jacket. 5 different people. We can pretend like 5 profiles doesn't mean 5 different people. That is what profiles mean. One person has one profile, 5 profiles mean 5 people. 5 different people are on the neck of that jacket. I was trying not to get into a whole bunch of DNA, but I don't think I can avoid it, unfortunately. So just bear with me. The beanie, a whole bunch of talk has been, about this beanie with cold-blooded on it. Y'all, I can, somebody can go out and buy a beanie with a Superman logo on it. Doesn't mean they're Superman. What the beanie says means nothing. So what's important about that is the DNA. Samantha Josephson's DNA is on that beanie. Nathaniel Rowland's DNA is on that beanie. You know why? Because he's worn it. It was on his head. There's video of him wearing it. Ms. Josephson's DNA is on it because it was in the car. The 2 other people who were present on that beanie, I don't know who they are. I don't know how they got there. But there's 2 other people in there. And we can't keep skipping over things that don't work for us. Keep skipping over things that don't fit into this nice little pretty box that I'm trying to give you. You have to look at everything. That's the oath that y'all took as jurors, to look at everything. Consider all the evidence, all the testimony before you make your decision on whether or not the state's proven their case. And when the state elects not to give you everything, I don't know how you're supposed to do your job. I really don't. There's a tan shirt that Mr. Goldberg brought up from the ATM video. Guess what? Nathaniel Rowland's DNA is not on the tan shirt. There's 2 people, Samantha Josephson and somebody else. In the 67-page report that Agent Dwayne issued in this case, that was the big one, not the one that she did in June of 2021, almost 2.5 years later. The 67-page report from December of 2019. There are 32 different times that Nathaniel Rowland is excluded from profiles. Or it's a combination, either excluded or involves other people. 32 different times. The items where he is supposed to be in his car on his belongings, the steering wheel, the gear shift, his hat, his sweatshirt that we know he loves to wear. We know that he's going to be there. The issue is everybody else. And I don't arguing that, I take that back. Trying to say that, an unidentified profile could be the manufacturer of a vehicle that's a number of years old. You don't have to be any DNA expert to realize that that's kind of a stretch. If you own a car for a number of years, the chances of the manufacturer's DNA being there, or somebody who did work on your car 4 months prior, it's not likely. It's possible. I'm not saying it's not possible, but it's not likely. The unknown profiles in that vehicle, they matter. The unknown men that are involved in this case, they matter. You can't just brush over them because it doesn't fit the story that the state wants you to believe. You heard from Dr. Beaver yesterday. What happened to Ms. Josephson, to say it's was a horrific experience. A vicious attack is an understatement. Over 100 wounds is a lot of wounds. But I can't get around how even Dr. Bieber is convinced that he was. I guess the first time seeing this in court, he just knew automatically it was the weapon. He explained the single, not the double wounds, the single wounds, as somebody using this tool in this manner to create this single blade. Y'all remember that? Now, how, in the backseat of a car, in the dark, with a young woman who is fighting for her life, somebody is supposed to hold this tool with a blade literally pointed in their direction and not injure themselves in some way? How somebody does that is beyond me. It's this long when it's together. Y'all look. Let's try it again. Look at it. Wildly swinging, wildly stabbing, in whatever rage is going on, and there's not a cut on him? How do you accomplish that with this? Like I said, he readily just identified it. He was really excited. He wanted to let y'all know he had identified the murder weapon after seeing it for 10 seconds while sitting on the stand. The cause of death in this case was never a question. Never. Nobody ever said that Ms. Josephson was not stabbed and died because of those injuries. I don't know what Dr. Bieber's intentions were. I don't know why he tried to explain to y'all that Ms. Josephson's fingernails were too short to get DNA under them after we already had testimony that they collected DNA out from under them. I don't know what that show was about. But this young lady had over 100 stab wounds. There is evidence on her body. There's bruises. She has discoloration of her knuckles. Either she hit something or something hit her. Her fingernails were ripped, even though some witnesses don't want to admit that they were after the fact. We know from SLED that they were ripped. We know from SLED that they were of medium length. Not the short nails that Ms. Goo showed y'all yesterday. She barely has nails. His report said medium length, and they were ripped. That's what we know. She put up a fight, and Nathaniel Rowland had not a mark on him. That is what we know. There's a footprint in the window. Her fingernails are ripped. She's got bruises. She's got defensive wounds. She didn't lay there. She didn't give up. We never suggested that she did. They've never suggested that she did. This young woman fought. And Mr. Goldberg said that she left a trail with her footprint. Well, she gave y'all the conclusion with her nails. She told y'all who it was. Now, I've touched on a few of the, things that I guess just were overlooked at being introduced to you. The photographs of Nathaniel that were taken by Agent Jazik that showed absolutely no injuries. They didn't even ask him about it. Ask her about it. They didn't even ask her. They said, "Did you respond to headquarters?" "Yes, I responded to headquarters." "And what did you do?" "Well, I took some photographs." "And did you collect the clothes?" "Yes, I collected the clothes." They didn't even ask her. Just wanted to brush on by it like it didn't matter. She told you in great detail. Ms. Good asked her in great detail. "You took pictures of the back of the hands?" "Yes." "Front of the hands?" "Yes." Both sides of the arms, yes. His face, his neck, and there wasn't a mark on his body. If there had been, y'all would be looking at those pictures. If Ms. Josephson had Nathaniel Rowland's DNA under his fingernails, do y'all think they would have left that out? How many times do you think they would have had the DNA analyst on the stand confirming that his DNA is under her fingernails? How many times? But because it's not there, they don't want to talk about it. They want to tell you it doesn't matter because it doesn't work for them. Some of the videos that y'all are going to be able to watch, I do ask you to watch them. Please watch them. Y'all aren't going to be able to take the big TV back there, but you'll have some device in your jury room to watch these videos. The PDF that was, the PowerPoint presentation that Mr. Martin showed y'all yesterday, that was our first time seeing it too. We don't have a Justin Martin in our office, so we were just sitting there watching 25 plus hours worth of video, doing the same thing, staring at these videos, trying to identify cars, where they were going, how can we try to get some sort of timing on what was going on? Do we see the driver of the vehicle? That one video y'all have, the wrong turn down Saluda. Mr. Goldberg showed it to you today, a short clip. You'll be able to watch it. And if you remember, when Mr. Shealy was on the stand, I asked him, he's the owner of Statewide Security, where they got all these videos from. I asked him to confirm whether or not he had a second camera on Saluda. And he does. So we're all familiar with 5 points. I assume we're all familiar with 5 points. If you are at Gourmet Shop or at the Fountain or at Starbucks, that intersection heading into Shandon is Saluda Avenue. You can see the vehicle turn left, going the wrong way, and travel down in front of Gourmet Shop. Right before you get to Gourmet Shop, right where that car turned, there is a camera that is literally pointed into the driver's side of a car. It is directly in the street. It's got 3 or 4 different angles on it, but one of the...
Yes, sir. Basis for the objection.
Argument about facts not in evidence.
I can move on, Raj.
All right.
He told you there is another camera there. And the only reason you don't have that footage is because law enforcement never asked for it. They never asked for it. They bring you all this other stuff, but they never asked for it. And unfortunately, we were not given the opportunity to ask the investigators in this case why they didn't ask for it. Did y'all notice that none of them testified? None of the lead investigators in this case testified. They've been sitting here all week. This end, that end, and then Investigator Owens is sitting right behind them. None of them testified. So we couldn't ask questions. Why didn't you do this? Why didn't you look into this? Did you follow up on something? Did you follow up when you got the DNA reports? Did you follow up on anything? Because they didn't put them on the stand. I cannot tell you why, but I can tell you they've been here all week and y'all have not heard from them. We couldn't ask them any questions. Now the state has the burden. You'll hear from the judge and you heard from Mr. Goldberg. The burden of proof. The burden of proof is not a small thing. It is proof beyond a reasonable doubt. Proof beyond a reasonable doubt. Everybody has a different definition on what that means. Everybody explains that differently when they're talking about it. What it boils down to is hesitation. A hesitation to act. And the hesitation Doesn't have to be long. The hesitation can be a split second. That's reasonable doubt. If you think for half a second, that's hesitation. If before you put your pen to the paper, you pause, that's hesitation. That's what beyond a reasonable doubt is. That's how you make this decision. And y'all hold them to their burden. Hold them to it. Making poor choices, not calling law enforcement, riding around in a car you know that you should not be driving around in, does not mean that you are guilty of murder. It does not mean that you are guilty of kidnapping. If that's the case, then Maria Howard should have been charged too, because y'all, she drove the car twice with her baby in it. Just because you do things that seem completely irrational, because they are, it's completely irrational to drive around in a car with blood in it, does not mean that you are guilty of murder. They have to prove that Nathaniel Rowland killed Samantha Josephson. Nothing on this table and nothing from that box proves that. They have to prove that he kidnapped Samantha Josephson. Again, nothing on this table and nothing from that stand proves that. They've created a narrative, and he's the villain in their narrative. Because for them, he is the easy answer. He is the simple answer. In this case, it's the wrong answer. It is the wrong answer. The state said that they understand their burden, they welcome their burden. They don't have a choice. They have to meet their burden if y'all are going to vote to convict. They have to. They cannot reject it. It is their burden. Y'all hold them to it. March 29th, 2019, the unthinkable did happen. Samantha Josephson's life was cut short in the most violent way. Nobody has stood up here and told y'all that she deserved what happened or tried to blame her in any way. Anyway, what happened to her is tragic. It is heartbreaking. And this is an emotional case. It is an emotionally charged case. I know it. The state knows it. Everybody in here knows that. But as jurors, I used to believe I could ask juries to put your emotions aside, leave them at the door. Y'all are human beings. Me asking that of you, it goes completely against human nature. You can't check your emotions. That's part of who we are. What I can ask of you is to not let your emotions dictate your decision. Don't let your emotions, the fact that this is a sad, tragic, heartbreaking case, dictate your decision when you go deliberate. That's what I can ask of you. The state has not proven that Nathaniel Rowland kidnapped Samantha Josephson. They have not proven that he has killed her, and they have not proven that he had a weapon during those crimes. What they proved is that he tried to sell her cell phone. He's not on trial for that. What they proved is that he did not call law enforcement when he should have. He's not on trial for that. They have failed at meeting their burden. I ask that you find him not guilty. Thank you.
Ladies and gentlemen, let's all stand for a moment. Okay. Madam Foreperson and members of the jury, you've heard the testimony, received the evidence, and you've heard the arguments of the state and the defendant. I will now explain to you the law that applies to this case. Under the Constitution and laws of South Carolina, you are the finders of the facts in this case. I do not have the right to pass upon the facts or even to express any opinion that I might have as to them, because this is a matter solely for you, the jury, to determine. As jurors, then, it is your duty to determine the effect, the value, and the weight of the evidence presented during this trial. Now, as the trial judge, it is my duty and responsibility to preside over the trial of the case, and I also have the duty to pass upon the admissibility of the evidence offered during the trial. You are to consider only the testimony which has been presented from this witness stand, together with any other evidence or exhibits presented and made a part of the record, and any stipulations made by counsel. I have the additional duty to charge you the law applicable to this case, and as the presiding judge, I am the sole judge of the law of this case. It is your duty as jurors to accept and apply the law as I now stated to you, then deliberate in an effort to reach your verdict. And finally, I charge you in this regard that you should not be concerned with what you think the law ought to be, but what I charge you that the law is. You are also the judges, the sole judges of the credibility, that is the believability of the witnesses who have testified and of the evidence which has been offered. In considering credibility, you may take into consideration many things, such as the demeanor or manner of testifying, whether the witness had reason to be biased or prejudiced, or whether a witness's testimony was contradicted on the one hand, or corroborated and supported on the other hand. You may believe a small portion of a witness's testimony and disregard the larger, or vice versa. All these things you will consider, bearing in mind that you should give the defendant the benefit of any reasonable doubt. It becomes your duty as jurors to analyze and to evaluate the evidence and determine that evidence which convinces you of its truth. There are two types of evidence which are generally presented during a trial: direct evidence and circumstantial evidence. Direct evidence directly proves the existence of a fact and does not require deduction. Circumstantial evidence is proof of a chain of facts and circumstances indicating the existence of a fact. Crimes may be proven by circumstantial evidence. The law makes no distinction between the weight or value to be given to either direct or circumstantial evidence. However, to the extent the state relies on circumstantial evidence, the circumstances must be consistent with each other, and when taken together, point conclusively to the guilt of the accused beyond a reasonable doubt. If these circumstances merely portray the behavior of the defendant as suspicious, the proof has failed. The state has the burden of proving the defendant guilty beyond a reasonable doubt. This burden rests with the state regardless of whether the state relies on direct evidence, circumstantial evidence, or some combination of the two. Normally, a person cannot give opinion testimony. When a person testifies, they must testify as to what they either saw, heard, or sensed by smell or something of that nature. However, there is an exception when someone is qualified because of education or experience. These witnesses, expert witnesses, are permitted to give their opinion in certain areas if the court qualifies them that way. To give opinion testimony in that area, that does not mean that you must accept the opinion, but it is evidence for you to use in any way you see fit and give it the weight and credibility you believe is appropriate. I instruct you and emphasize that the fact that the defendant did not testify is not a factor to be considered by you in any way in your deliberations and in your consideration on the question of the guilt or the innocence of the defendant. It must not be considered by you in any manner whatsoever. A defendant has the constitutional right to remain silent, and the assertion of this right must not be considered by you in your deliberations. I repeat, under your oath, you are to draw no conclusions whatsoever from the fact that the defendant did not testify. The fact that the defendant did not testify should not even be discussed in the jury room. The burden of proof, as I have stated to you, is on the state. The defendant is not required to prove his innocence. The burden of proof remains on the state to prove guilt beyond a reasonable doubt. The fact that the defendant was arrested, charged, and indicted in this case is not evidence and cannot be considered by you as evidence of guilt, nor does it create any presumption or inference of guilt. These indictments are simply the formal written instruments which contains the charges made against the defendant. The indictments are the formal documents by which this case is brought into this court. The defendant has pled not guilty to each of these indictments. That plea puts the burden on the state to prove the defendant guilty. A person charged with committing a criminal offense in South Carolina is never required to prove himself innocent. I charge you that it is an important rule of the law that the defendant in a criminal trial, no matter what the seriousness of the charge may be, will always be presumed to be innocent of the crime for which the indictment was issued, unless guilt has been proven by evidence satisfying you of that guilt beyond a reasonable doubt. This presumption of innocence does not end when you begin your deliberations, but it accompanies the defendant throughout the trial until you reach a verdict of guilt based on evidence satisfying you of that guilt beyond a reasonable doubt. The presumption of innocence is like a robe of righteousness placed about the shoulders of the defendant, which remains with the defendant until it has been stripped from the defendant by evidence satisfying you of the guilt of the defendant beyond a reasonable doubt. The presumption of innocence is not a mere legal theory. It is not just a legal phrase. It is a substantial right to which every defendant is entitled unless you, the jury, are satisfied from the evidence of the guilt of the defendant beyond a reasonable doubt. The state must prove the defendant guilty beyond a reasonable doubt. So what is a reasonable doubt in the law? A reasonable doubt is a doubt which makes a reasonable, honest, sincere, and conscientious juror hesitate to act. Proof beyond a reasonable doubt must therefore be proof of such a convincing character that a reasonable person would not hesitate to rely and act upon it in the most important of his or her own affairs. Proof beyond a reasonable doubt can also be described as proof that leaves you firmly convinced of the guilt of the defendant. Now, there are very few things in this world that we know with absolute certainty. And in criminal cases, the law does not require proof that overcomes every possible doubt. If based on your consideration of the evidence, you are firmly convinced that the defendant is guilty of a crime charged, you must find him guilty. If, on the other hand, you think there's a real possibility that he's not guilty, you must then give him the benefit of the doubt and find him not guilty. The indictments allege 3 different offenses against the defendant. The charges are kidnapping, murder, and possession of a weapon during commission of a violent crime. Each indictment charges a separate and distinct offense. You must decide each indictment separately on the evidence and the law applicable to it, uninfluenced by your decision as to any other indictment. The defendant may be convicted or acquitted on any or all of the offenses charged. You will be asked to write a separate verdict of guilty or not guilty for each indictment. The defendant is charged with kidnapping Samantha Josephson. The state must prove beyond a reasonable doubt that the defendant knowingly and unlawfully seized, confined, inveigled, decoyed, kidnapped, abducted, or carried away another person without authority of law. To do a thing unlawfully is to do it willfully against the law. Knowingly means with knowledge, consciously, not accidentally. Seize means to take hold of suddenly or forcibly. Confine means to limit, restrict, or enclose within bounds, imprison, shut, or keep in. Inveigle means to lure, entice, or lead astray by false representations, promises, or other deceitful means. Decoy means to lure by, or as if by decoy. A decoy is something to entice a person into a trap. Kidnap is to remove a person against her will by unlawful force or by fraud. Abduct means to carry off secretly or by force for an illegal purpose. Carry away means to remove. The state does not have to prove that the defendant did all of these things. Instead, if you find beyond a reasonable doubt that the defendant did any of these things, you may find the defendant guilty of kidnapping. Something done without authority of law is something which the law does not sanction, permit, allow, condone, or provide justification for. Kidnapping does not have to be for any personal or monetary gain, for any illegal purpose, but may be for any reason whatsoever. The defendant is also charged with the murder of Samantha Josephson. The state must prove beyond a reasonable doubt that the defendant killed another person with malice aforethought. Malice is hatred, ill will, or hostility toward another person. It is the intentional doing of a wrongful act without just cause or excuse, and with an intent to inflict an injury or under circumstances that the law will infer an evil intent. Malice aforethought does not require that malice exists for any particular time before the act is committed, but malice must exist in the mind of the defendant just before and at the time the act is committed. Therefore, there must be a combination of the previous evil intent and the act. Malice aforethought may be expressed or inferred. These terms, expressed and inferred, do not mean different kinds of malice, but merely the manner in which malice may be shown to exist. That is, either by direct evidence or by inference from the facts and circumstances which are proven. Express malice is shown when a person speaks words which express hatred or ill will for another, or when the person prepared beforehand to do the act which was later accomplished. For example, lying in wait for a person or any other acts of preparation going to show that the deed was within the mind of the defendant would be expressed malice. Malice may be inferred from conduct showing a total disregard for human life. The defendant also is charged with possession of a weapon during the commission of a violent crime. The state must prove beyond a reasonable doubt that the defendant was in possession of a weapon during the commission of a violent crime. A weapon is any article or instrument which is likely to cause death or great bodily harm. Whether an instrument has been used as a weapon depends on the facts and circumstances of each case. In order to find the defendant guilty of possession of a weapon during the commission of a violent crime, you must find the defendant guilty of committing a violent crime. Murder is a violent crime. The state must prove beyond a reasonable doubt that the weapon furthered, advanced, or helped in the commission of a violent crime. An issue in this case is the identification of the defendant as a person who committed the crimes charged. The state has a burden of proving identity beyond a reasonable doubt. You must be satisfied beyond a reasonable doubt of the accuracy of the identification of the defendant as a person who committed the crime or crimes before you may convict the defendant. Identification can be proven by direct evidence, circumstantial evidence, or a combination of both. if after examining the evidence you have a reasonable doubt as to the accuracy of the identification, you must find the defendant not guilty. Now, while the arguments of counsel are a beneficial part of every trial, you should remember that the statements made by counsel are not evidence. In presenting their arguments, counsel often refer to the evidence. However, you should base your verdict on the evidence as you remember it. If there are any conflicts between the recollection of counsel about the evidence and your own recollection, you should rely on your own understanding of the evidence. Now, Madam Foreperson and members of the jury, I am required to charge you the law as I have done through these instructions now being given to help guide you to a just and lawful verdict. Whether some of these instructions apply will depend upon what you find to be the facts. The fact that I have instructed you on various subjects must not be considered as indicating an opinion of this court as what you should find to be the facts or what your verdict should be. Now, you've been chosen and sworn to give the parties a fair and impartial trial. When you have done so, you will have complied with your oath, and no one will have a right to criticize your verdict. You must not be influenced by opinions or expressions of opinions you may have heard outside of the courtroom, but rather should base your verdict solely on the testimony of the sworn witnesses who took the stand, the exhibits received into evidence, and the law which I have stated. You should not be swayed by caprice, passion, prejudice, or improper sympathy for or against anyone. Remember, you have no friends to reward or enemies to punish, and all parties are entitled to a fair and impartial trial. It is your duty as jurors to consult with one another and to deliberate in an effort to reach an agreement. Each of you must decide this case for yourself, but only after impartial consideration of all of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if you become convinced it is erroneous. However, do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. As I stated earlier, you are the judges of the facts. Your verdict must represent the considered judgment of each juror. In other words, your verdict must be unanimous. Now, you may have noticed I have read these instructions. I do so to give you the law as accurately as possible. I will give you a copy of these instructions to have in the jury room. You may refer to these instructions to assist you in your deliberations. You must consider the instructions as a whole and may not follow some and ignore others. And Madam Foreperson, it will be your duty to preside over the deliberations of the jury. If, during your deliberations, you should desire to communicate with the court, please reduce your message or question to writing, signed by your foreperson and the foreperson only, and pass the note to the bailiff, who will bring it to my attention. I will then respond as promptly as possible, either in writing or by having you return to the courtroom. I caution you, however, with regard to any message or question you might send, that you should never state or specify your numerical division at the time. Now, you've heard the evidence and you've heard the law. Whatever your verdict, Madam Foreperson, you will indicate it on the back of each indictment and then sign and date your verdict. And each indictment that'll go back with you has a space for verdict on the back, and your verdict will be guilty or not guilty. Whatever your verdict, you write it below the word verdict, sign and date it, Madam Foreperson. Remember that although the foreperson is the only juror who writes the verdict, it is not hers alone. The verdict has to be unanimous. And Madam Foreperson, you're not authorized to write the verdict until all of you have agreed to the verdict. Now, ladies and gentlemen, I will send you to your jury room, and the jury room will be a room where all of you will be together. But do not begin your deliberations until you receive a copy of this jury charge, the indictments, and the exhibits. Once you receive these things, that will be your signal to begin your deliberations. Once you begin deliberations, you will deliberate until you have reached a verdict, at which time you will knock on the door, advise the bailiff, and we will bring you out to receive your verdict. And certainly I understand that it's approaching lunchtime, and we have ordered lunch for everyone, and the order in which you eat or deliberate, Madam Forelady, and members of the jury, that is entirely up to you. Whether you want to break within the jury room and eat, or deliberate first, or deliberate while eating, it's in your hands, whatever you do. Now, we've selected 4 alternate jurors. Quite often during the course of a trial, something comes up, and one juror cannot continue with deliberating, or one juror might have some personal issue or problem, and we have to then use an alternate juror. In this case, due to the length of the trial, we picked 4 alternates. However, out of the first 12 jurors selected, if you have any reason why you cannot continue with deliberations, please let me know at this time by raising your hand if there are any problems within the first 12 jurors that would prevent you from deliberating in this case. If you have a problem, such a problem, please raise your hand. All jurors, therefore, appear to be in good shape and able to continue with deliberations, which means that the 4 alternates elected will remain with us in the courtroom while the other 12 jurors report to the jury room. So please report to the jury room at this time, all except the 4 alternates who were selected.